Welcome to the Arbitration World podcast, in which we focus on significant developments and issues impacting international arbitration. We hope you enjoy this discussion. Please do get in touch with us if you have any questions about this week's episode or any areas you would like us to cover in a future podcast in this series.
Welcome to another in our series of podcasts which are focused on cases, developments, and issues impacting international commercial and investment arbitration. My name is Emma Lidström, and I'm a Commercial Disputes Associate in the London office at K&L Gates. I have a varied practice focusing on litigation and international arbitration. This podcast today is the first in our new mini-series titled The Road to Net Zero and the Implications for the World of International Arbitration. In a moment, I will introduce our guest speaker for this series, who is well-versed in this fascinating area of climate change, the energy transition, and international arbitration. Before we get started, I have some brief comments by way of introduction. This presentation is limited in scope, as appropriate for a general audience and applicable time constraints. This presentation is not offered as legal advice, which should only be obtained from properly licensed legal professionals on the basis of the specific facts of a given case. All speakers appear in their personal capacities, and any opinions or views offered are those of the speaker alone and do not necessarily reflect the opinions or views of K&L Gates LLP or any other entity or individual. And with that, let's get started with the podcast. For this podcast mini-series, I'm joined by Wendy Miles, KC. Wendy is a barrister and a specialist in international arbitration and dispute resolution, with a focus on private and public international law. Wendy has conducted arbitrations under all the major institutions and has assisted clients across numerous sectors, including energy, natural resources, and construction. In the specific field of climate change, Wendy acts as global coordinating counsel to various major corporates in relation to climate change transition, disclosure, reporting, compliance, and investment. She regularly advises investors and states in respect of climate-related physical transition and litigation risk. She works closely with a number of states in relation to climate transition regulatory structures and formulating climate investment policy. She's the founder of the Net Zero Lawyers Alliance and has also represented the International Chamber of Commerce, the ICC, at the Conference of Parties on Climate since 2015. Thank you so much for agreeing to participate in this podcast series, Wendy.
It's a pleasure. Lovely to be here, Emma.
This episode will serve as an introduction to the topic of the path to net zero while we explore the general trends that we are seeing in the international arbitration world and how that may be related to the energy transition. Wendy, I would like to start by asking you what trends you are seeing in the work that you are involved in within the context of the energy transition.
The trends we're seeing, Emma, in the energy transition are a rapid transition from traditional fossil fuel related electricity generation to renewable energy generation. So on the 3rd of June 2024, the Conference of the Parties, 29th Conference of the Parties Intersessional, the meeting in between the main COPs, open in Bonn, Germany, and the International Energy Agency, the IEA, gave a speech to warn the 200 government delegates that clean energy plans that those states have committed to are currently falling almost a third short of what's needed to reach the agreed renewable energy goal for 2020. So the role of the negotiations both in June and November 2024 is to ensure these goals are achieved by mobilizing political will and commitment, finance and technology. And that goal is to triple renewable energy supply by 2030. So the fact that the IEA reports that we're only a third behind at present and further states that it's confident we can achieve the goal of tripling renewable energy demonstrates to me that there is rapid and deep growth in renewable project investment that we're seeing already, but that we're going to see in the coming years. Remember, 2030 is only 5.5 years away from where we sit today. So in terms of the types of investment agreements that are required in order to achieve this transition, they're going to cover each and every step of the energy cycle. So if we think about what we know about traditional fossil fuel energy generation cycles, we go from exploration and production, refining, transportation, pipelines or other transport, storage, and then to the power generation plant, which needs to be constructed or maintained, operated, and the distribution grids. So the renewable energy cycle, it has very similar steps from exploration and production of mining critical minerals and metals as opposed to oil and gas, refining, processing those same materials, their transportation, their use in the construction of renewable power generation plants as opposed to the supply of the energy source. And then also there's the distribution element. Has some similarities and some differences. And many of the same actors are involved in this transitioned energy system as well. Manufacturers and EPC contractors supplying turbines for wind farms are often the same manufacturers who applied the turbines for gas-fired power plants, for example. But the scale of manufacture required to triple renewable projects is unprecedented, puts enormous pressure on a small number of large manufacturers and EPC contractors. And the other thing that is going to, I think, change exponentially is the role and prevalence of mining development agreements, concessions licenses for exploration, development and production of critical minerals. States need to fund their climate change adaptation, resilience building, and the sale of sovereign resources can contribute significantly to the cost of that transition, including and often especially in less developed states.
Thank you, Wendy. That's very interesting. And you touched upon this in your answer, but from your point of view, how is the energy transition impacting international arbitration? And then in turn, how is international arbitration impacting the energy transition? And in the future, how do you see it possibly impacting it further?
In terms of international arbitration, it plays a critical role in this energy transition. If you think of the transition at its simplest, it's investment, new investment in scaling up renewable energy infrastructure and phasing out fossil fuel energy systems. And that scaling up and that phasing out will both engage cross-border contracts, which more often than not already have embedded in them international arbitration agreements. So for the scaling up of renewables, we're going to see more contracts. And as I say, they typically contain arbitration agreements. So disputes under those contracts will, at least initially, be heading to arbitration. For fossil fuel, disputes under existing contracts are likely to become more complex as states start to implement their commitments under the Paris Agreement into their mandatory law frameworks. And we're seeing a bit of that now in Europe. For example, the Netherlands phasing out its coal-fired power generation facilities. So international arbitration is central. It's already central because it's the dispute resolution mechanism that's already in place in many of those existing cross-border contracts and contractual practices. It's often the dispute resolution mechanism of choice for corporates in cross-border trade and investment. And we know that's because international business and industry has long sought commercial, flexible, and internationalized dispute resolution wherever possible. And the New York Convention on the Enforcement of Arbitral Awards continues to underwrite this choice, ensuring greater enforceability of these awards than national court judgments in foreign courts. So the ICC Court of Arbitration figures show us that almost 3/4 of their disputes over the last 20 plus years have fallen within the broad categories of energy and infrastructure, and that includes natural resources, so mining. The London Court of International Arbitration has a greater proportion of finance-related disputes relatively than the ICC, But frequently, those are financing arrangements to fund energy or natural resource projects. So as to whether arbitration ultimately continues to be the dispute resolution mechanism of choice through this transition, that depends. Right now, it's the default because that's what parties have chosen. But whether it remains the case, that depends. The English courts, for example, are excellent, and they have potential advantages over arbitration in terms of additional parties to proceedings, multi-party proceedings, where arbitration often can't incorporate interested parties outside the direct contract. They have the value of precedent setting, binding authority, and predictability, which is going to be critically important in a rapid and uncertain transition. Corporates want to know where they stand. There's judicial expertise, and robust decision-making is often attributed to judges, but I think one can choose one's arbitrator to achieve the same. But publicity and transparency is the flip side of the confidentiality that business and industry value so much in arbitration. But this transition to succeed needs a degree of transparency. So the procedures of the courts to deal with matters quickly, summary disposition, and the rights of appeal, these could all become advantages in what is at its core a systemic transition, a global and systemic transition. So it remains to be seen whether arbitration continues to be a more attractive option for this transition, because if our goal is genuinely to achieve the Paris Agreement commitments on mitigation, adaptation, and resilience building globally, we're going to have to bring those commitments into the arbitration process. We need to understand as counsel and arbitrators and apply the mandatory laws that states are rapidly putting in place in the place of performance and place of registration. So the jury's out, Emma, whether international arbitration will be able to do this as well as national courts, or potentially better. The jury's out. But ultimately, it may be the national courts that decide through enforcement or challenge proceedings under the New York Convention. One thing that concerns me a little bit is we've created a system where our courts, almost globally, in states that are parties to the New York Convention, are now so differential to arbitral awards, and the commercial choice of the parties to entrust their disputes to those bodies over the courts, that we may have created a rod for our own backs. We've seen some recent decisions in the UK courts, and particularly the PND and Nigeria case, that I think is a bit of a pushback on that, at least in mixed arbitration proceedings where there's a state party involved. But I personally would be disappointed to see an international arbitration system of enforcement that doubled down on protecting commercial party autonomy over and above the purpose of those mandatory laws that states are putting into place to facilitate this transition.
That brings a close to this first podcast in our Canal Gates series, where we discuss the road to net zero and the implication for the world of international arbitration. Wendy, thank you for sharing your insights today. I invite our listeners to join us again in listening to our upcoming podcast in this series, where we will be discussing the types of disputes emerging from the energy transition, as well as investment treaty claims relating to renewables. Thank you for listening, and goodbye for now.
Thank you for listening to this episode of Arbitration World Podcast. To listen to past episodes and receive notices for new episodes, subscribe by searching Hub Talks, that's HUB Talks, in your favorite podcast app. We hope you will join us next time for further discussions on hot topics and significant developments in international arbitration from around the globe.